Right now, manufacturers and the DNR are arguing over how the government handles pollution from businesses.
This morning at the state capitol, the Wisconsin Supreme Court heard a case between Wisconsin Manufacturers and Commerce versus the DNR, and our Merrill Hubbard is here now to break down the crux of the case.
At the center of this argument is how people interpret the Wisconsin spill law, which requires anyone who causes, possesses, or controls a hazardous substance that was discharged into the environment to take action to restore the affected air, land, and waters. The argument is about the DNR's ability to address toxic PFAS under that law.
Respondents' position would fundamentally rewrite the spills law.
Colin Roth, representing the DNR, explains that the spill law has been used for nearly 50 years.
The spill law has worked so well for decades, precisely because the legislature broadly defined the hazardous substances that dischargers must report and clean up.
The respondent, WMC, represents Leather Rich, a small family-owned dry cleaning business based in Oconomowoc.
Ms. Cantor has spent 6 years and several $100,000 just trying to decipher what the law requires of her.
The respondents question how the DNR regulates pollution that comes from their client's business and suggest the legislature play a larger role in rulemaking.
It's a fundamental principle of our legal system that regulated parties have fair notice of what is forbidden or required of them. And that's why rulemaking is required here.
This take received sympathy from Justice Rebecca Bradley.
Where's the help? Is that your argument?
And some criticism from Justice Jill Karofsky.
How is DNR supposed to communicate with your client when communicating with your client leads to you suing them? They were communicating with their client about these very issues.
The DNR argues that more rulemaking will slow down its ability to combat pollution from PFAS and other contaminants, standing by the spill law.
If agencies cannot administer laws like this one without rulemaking, executive branch activity would grind to a halt.
The Supreme Court could rule on this case within the next couple months.